Now that your Maryland uncontested divorce hearing has been scheduled, we know that that date can come up much quicker than you expected. While the uncontested divorce hearing itself is fairly simple, the notion of having a court hearing can be sometimes intimidating and confusing. So, with that in mind, here are a few tips on what to expect for your Maryland uncontested divorce hearing. I'm Carrie Jacobson with Jacobson Family Law, where we keep the drama out of your divorce. The first thing to be aware of is that now most uncontested divorce hearings are typically held virtually. And so you should receive, if you haven't already, a copy of login instructions for a Zoom date or a telephone conference for your hearing date. So be sure to have those available to you and try to log in several minutes before your scheduled time, just to be sure that all of your equipment is working properly. Once you've entered the virtual courtroom, make sure that you have your mic muted, but your video camera on, and that you're prepared to respond once your case is called. Unless specifically instructed otherwise by your attorney or the court, there's really no reason to have anything with you other than maybe a copy of your marital settlement agreement, just so that you can refer to it for any questions that may be asked of you, so that you know exactly where those items can be found. The uncontested divorce hearing itself typically takes about 5 to 10 minutes. However, there are sometimes situations, even in virtual court, where you have to wait your turn for your case to be called because multiple cases may be scheduled at the same time. So be ready to be patient. During the hearing, either your attorney or the family law magistrate will be asking you questions related to the content within your complaint. These could be things like, when and where were you married? Was it a religious or a civil ceremony? What are the names and dates of birth of your children? When did you and your spouse separate from one another? And some of the terms within your separation agreement. It should be noted that a family law magistrate is not the same as a judge, and they do not have the same signature authority that a judge does. He or she will listen to the testimony, and they will prepare what's called a written report of recommendations of some of the facts that they've heard during your testimony. Then they can make a recommendation as for the divorce to be granted. Unless otherwise waived by you and your spouse, there's a 10-day waiting period for either you or your spouse to file exceptions. These exceptions are also sometimes referred to as an appeal. And once that 10-day period has elapsed, the judgment of absolute divorce will then be submitted to a judge for signature. However, you and your spouse may be able to waive that 10-day exception period either by making the request during the hearing itself or filing an acknowledgement and request to waive that 10-day period. The final divorce date will be once the judge signs it and it's actually stamped in by the clerk's office. You may receive a copy of the original gold seal version of the judgment of absolute divorce. Some courts mail that out, and other courts you have to make a request to obtain that directly from the clerk's office. This document may be important for a couple of reasons. The first would be if you're asking to restore the use of a former or a maiden name. You're going to need a copy of that gold sealed judgment of absolute divorce to submit to Social Security and the MVA to have your name legally changed. If you do not decide to ask for that relief to restore your maiden name during the time of the divorce, you have up to 18 months after the divorce to make that request without any additional court costs. Additionally, you may need a copy of that judgment of absolute divorce if you are dividing retirement accounts from your spouse. You may also have to submit something called a quadro or a qualified domestic relations order. This is a separate document that gets submitted to the court requesting the judge's signature so that retirement benefits can be divided. Once the judge signs that document, you will have that along with your judgment of absolute divorce submitted to the plan administrator so that the accounts can be divided as necessary. And finally, you may also need a copy of your judgment of absolute divorce if you're receiving child support through the Office of Child Support Enforcement. Once you have that, you can file a case with the Child Support Enforcement Office to have those payments effectuated. You typically will receive your judgment of absolute divorce approximately 2 to 4 weeks after your final divorce hearing. If you have questions about anything regarding your uncontested divorce, or if you would like Jacobson Family Law to help guide you through an uncontested divorce, contact us at the link below and we would be happy to help.